My name is Michael Thomas from the Chattanooga Bar. My first time appearing before the Nashville Court, or the Middle Division District Court of Appeals, so not quite as comfortable with y'all as I would probably with some of my Court of Appeals judges. So
we're actually nicer
this morning.
So don't worry. We're actually nicer, so don't worry about it.
It's much stuffier in the East.
It is much cozier in this room.
Yeah,
When you take a look at the
absolutely,
East,
yeah.
Where I think I have to yell to reach up to the bench, and I usually have counsel sitting right here nudging me, telling me I'm wrong the entire time. So hopefully this won't take too much long. I'll reserve 5 minutes. And I don't even think I'll take the 10 minutes that I have. Before your honors is a healthcare liability action case. This is an appeal where the appellant is questioning the validity of an executed informed consent document combined with oral consent given during a appointment prior to a cryoablation procedure performed on the plaintiff.
Would you say the heart of the issue here is what is sufficient at summary judgment stage to overcome the presumption that we have to grant the fact that there's a signed consent?
Correct, Your Honor, and that's why I think we're not going to talk about this too long. If we find that the informed consent document is valid, we have nothing more to discuss. The trial court was correct. We are now entering into that overcoming the presumption that it's correct, not the bright line that it's correct. So here we have a patient who suffered from macular degeneration, couldn't read. His wife attended all of his medical procedures with him.
Counsel, is there any notice to Vanderbilt that he couldn't read? Is there anything in the record that suggests that, or would indicate that Vanderbilt would be on notice that he was having these vision problems, and so when they gave him a form, he was going to have limitations in terms of how he was going to be able to read it?
I don't think there is, Your Honor.
Wouldn't the medical records indicate that?
That's a good question, Your Honor.
Thank
While
you.
I have gone through the medical records, his medical records extend from Chattanooga to Nashville. Basically, the beginning of this case involved, this case was referred to Dr. Hebert on the ground that his original doctor had told him, look, we're going to go in and remove part of your kidney. However, and during that informed consent, I need to let you know about this cryoablation procedure, in which he was sent up to Dr. Hebert because this seemed like a less invasive procedure that wouldn't require death or loss of part of the kidney. So I don't have the knowledge of what actually followed from his previous doctor who diagnosed him in Chattanooga to a different facility up in Nashville at Vanderbilt, of whether those records were accessible or transferred. So the answer is I don't know, Your Honor.
There's no indication here that when the Vanderbilt, when the nurse, medical professional who hands him the document, though, he doesn't say, I have a vision problem, I can't really read this. There's no alerting of the person who's handing him the form that he has this problem in seeing, is there?
The statement that my client wished to convey, as put in the affidavit, is that as a matter of course, when he's handed a document to sign, he asks that it be read out loud. I'm assuming he did it in this case. However, I can't speak to it other than the blanket language that he says whenever someone hands me a document, I ask them to read it out loud. I can say, which is not in the record, every document that I've presented to him, I've had to read out loud from the get-go of this case, even before we established what the issue was. So in my course of dealing with him, yes. As to whether he did it up there, I don't know, and that might actually go to some of the confusion around this document, because we have this confidential relationship created by Benton v. Snyder. It's tantamount to this fiduciary relationship that provides this affirmative duty to disclose these facts surrounding the procedure to the client, to the patient. And here they disclosed that she's had a 100% success rate on this. It's a
Doesn't the document itself, though, disclose all of the side effects that your client says wish he had known?
It does, but my client, upon being presented with what they believe was the informed consent document, was, we need you to sign this. This is exactly what the doctor disclosed with you. This document is nothing more than what was verbally just told to you.
This document wasn't reviewed by the expert witness in this case, right? It wasn't provided to the expert witness in this case?
No, Your Honor, it was not during the initial stages.
Why isn't that fatal to the claim? I mean, as part of establishing an informed consent claim, don't you need expert testimony that establishes that there's a deviation from the professional expectations of how you obtain an informed consent?
Traditionally, yes. I believe 115 through 118 covers the situation where you have to have an expert testify as to whether informed consent is proper, because the layperson cannot interpret whether what was stated was proper enough. However, the expert did say that absent this document, there was no informed consent, and he did go into what needed to be disclosed. Here we have a case, I think, forgive me, I'm jumping all over the place on these questions, so my brain's not in order, but I did cite to a case that essentially says, when challenging the validity of the document, of whether the patient had knowledge of what was to be disclosed for informed consent, we actually go outside and don't require an expert witness. And I know that sounds strange, but I have it here in my.
Well, I mean, I guess the reason why I look puzzled, counsel, is it seems like to me that the argument you're making here is not validity, but inadequate disclosure.
Yes, Your Honor.
And so that's where you get, though, back to Judge Usman's question about, well, but you need an expert on inadequacy. And it seems like to me that your argument is sort of twofold, is that inadequate in terms of the oral disclosures that were made. You've got the spouse backing up your client's testimony on that part, but then you're confronted with this written document that he signed, and you're saying, well, that's inadequate because it wasn't expressed in a manner that my client could understand it because he couldn't read it. But you're sort of missing that component of to overcome the presumption of having an expert say, I've looked at this disclosure and it doesn't work here. I mean, this seems like what's missing here.
Well, in Cardwell v. Blanchard, which was the case that I was referring to earlier, it stands for the proposition that in a medical battery case, that expert opinion is not required when the question before the court is whether the patient knew of and authorized the procedure. And I see where we're kind of blending into, do you have to have the expert step in to say what the patient was supposed to know and what was known of? In this situation, if you take the affidavits of the facts in most light favor of my client, they can simply say there were no negative side effects provided absent, keep the injection site clean, otherwise you're going to have an infection. They assert that there was no statement along the lines of this could possibly freeze or cause renal failure or lose function in your kidney. We're asserting that absent this disclosure, if this disclosure itself was not provided correctly on the grounds that there's this confidential relationship in which she's required to disclose what is being said. And if she failed to do that, combined with, here's exactly what she said, then we have an omission, which is tantamount to a fraudulent behavior, as it's not fraud in our traditional sense, but the courts have considered this silence and or omission fraud, which would vitiate consent itself. That combined with Cardwell v. Blanchard saying you don't have to have the expert witness when the question is whether the patient knew of and authorized the procedure. Here we're saying he didn't know about it because it wasn't fully disclosed to him.
It seems to me your argument, a critical linchpin is his vision problem, his inability to read this. I'm struggling to understand, though, how Vanderbilt's supposed to operate under an understanding that he has this condition. So nurse, medical technician shows up at the room, he's handed the document. If he's not apprising, and so you're saying the affidavit says that he indicates he normally requires or normally asks someone to read, he always asks someone to read. What's the affidavit going to state? And maybe you can address it on rebuttal. It looks as if you're in search of the document.
I might have to go to my affidavit and take a second to look at that, Your Honor. Yes, I respectfully understand what you're trying to get there, but I think we're jumping into the informed consent document without looking at it in the sense of the allegation is that she talked about all the benefits, very little of any serious negative consequence, of which she has a confidential relationship requiring her to disclose this to her and disclose not only that, but alternatives. And in this case, we don't have to really discuss alternatives in the sense that this is the alternative to what the original matter was discussed. However, here, she had an affirmative duty, this confidential relationship, which required her to tell these side effects, tell him of these side effects. This combined with the follow-up statement of, here's a document I need you to sign, it's exactly what she said. Now we're having this.
Now, was that statement made? I mean, is the
It's
record?
in the affidavit.
So the affidavit says he was told this is what she said.
Yes.
Okay.
What they believe to be the document handed to them was essentially, here's a document I need you to sign. We've all been to hospitals before, and we all get handed a plethora of documents. As attorneys and jurists, we know that we need to read those.
Your time is up.
So, thank you, Your Honor.
Good morning, Your Honors. Ashley Tipton on behalf of the defendants, Vanderbilt University Medical Center, and Dr. Elizabeth Herbert. Thanks to Judge McBrier's question, you took out my whole first page of questions. You got straight to the point of the issue in this case is whether plaintiff met his burden for summary judgment of establishing when you go off, when this happens when you skip a page, my mind can't go back.
To overcome
the presumption of consent. Thank you.
Informed consent, right.
Yes. The trial court only granted summary judgment based on the consent form. Today, counsel has talked about these oral conversations that Dr. Herbert especially allegedly had prior to the consent form being signed, and it's also discussed heavily in the brief. Those oral conversations were not what summary judgment was granted on. Whether or not informed consent was orally given wasn't an issue. It's whether the consent form, which is was the presumption of that consent form was overcome by.
Doesn't the conversation have an effect on the form in terms of if I'm talking with my doctor who's about to perform this procedure and they say, this thing is the greatest thing since sliced bread, it goes well, never had any problems. The worst you can expect is that you might have a little infection around the site of the injection site. And then I'm handed a form that says something very inconsistent with that, and I could end up dying as a result of this procedure. Doesn't it affect how we understand the form if we've got the doctor saying something inconsistent with the form that's being signed?
In this case, with consent, there's two types. Again, you have this oral consent and then the written consent. With written consent, it's very understood in Tennessee law that if you sign a document, you are presumed to have read it and understood it. So it places the burden on the person signing that if it's different, to then ask questions. In this case...
So there is Tennessee case law addressing variances between where a doctor says, this is a great procedure, there's no problems, but the consent form lays out the parade of horribles that could happen to you. We have existing case law?
I don't think there's any case law on that exact issue. There's case law that talks about when a plaintiff doesn't read the consent form.
Right.
But they're still bound to it, but not your exact situation, no.
My concern here is what impact if I've got a doctor saying, great procedure, no problems whatsoever, you're going to be just fine, you don't have anything to worry about, there's no side effects, and then hospital comes in with a consent form that says there's all these terrible things that can, how do we look at the consent form as really giving truly informed consent? I mean, I just met with my doctor, and she said there's no side effects to this. And it seems like it has to impact the form. I mean, I understand your argument that you're pulling these two things apart, but aren't they more interrelated than that would suggest?
In this case, I think there's still the burden and the presumption of the written consent form. So it would fall upon any plaintiff or any person signing to read this and then to have that conversation. That, okay, what you told me a minute ago is different from what's on here, why is it different? And to not actually go through and sign that form if they have questions.
Well, I mean, couldn't another way of overcome the presumption, I guess, trying to put the hypothetical here and relate it to the facts of this case is, suppose the patient came to the table with an affidavit and said, yes, I signed this written consent form, but what the doctor told me was this is 100% surefire procedure, never has any adverse consequences at all. No one has ever complained about any kidney problems or anything. And I am not, on top of that, I am the #1 doctor in the land for this procedure, and you don't want anybody else in the world to perform it. That's the hypothetical. Wouldn't that be enough to overcome the presumption if you, and let's say on top of that, not only the patient says that, but my wife was in the room and yes, exactly what my husband said is exactly what the doctor told us. Wouldn't that overcome the presumption?
No, Your Honor.
And why not?
So I'm going to actually take a couple points on that one. First, again, we go back to the written consent form. Under Tennessee law, you're bound by the signature. Even if you haven't read it, or even if you only read over parts of it, you are bound unless you can overcome the presumption. And I'm going to go back to an earlier point, Judge Usman, that you had about expert. In this case, expert testimony is needed. In general, in an informed consent case, it requires it under 2926-118. Even outside of that, expert testimony is required in any case, even outside the healthcare liability realm, when an issue is outside the common knowledge of laymen. The standard procedure for how consent forms are presented, what must be told to a patient, if a patient has hearing problems, vision problems, if they have to be handled differently in that consent form process, if it varies depending on if they have family in the room, like in this case, or his wife, none of that is within the common knowledge of laymen. That requires an expert to come in and say, this was the procedure, and if this was said and he couldn't read or didn't read, that it would have been different or somehow rebutted the presumption of consent. There's no expert testimony in this case that provides that. As pointed out earlier, the expert affidavit submitted in response to summary judgment, he admits he's never seen the consent form. He offers no statements about misrepresentation or inadequate disclosure when it comes to that consent form. And I'll also note that affidavit by that expert was signed in, I believe, April of 2020. It was signed in 2020. This motion was not filed until 2022. But plaintiff never went back to that expert and said, here's the consent form. Have your opinions changed? Is there anything different?
Piggybacking on Judge McBrayer's question, do we need expert testimony then to be able to address the impact of the statement on the written document? Is that something that how you put those two things together? Does a plaintiff need to come in with an expert and say, here's how, when you've got doctor saying X and you have form saying Y, within the medical profession, here's how we would handle, there's the right way to handle that or understand that in terms of whether it's consistent with proper medical care?
If plaintiff is relying on that oral conversation to overcome the presumption of consent from a written document as established by Tennessee case law, then yes.
Okay, so my hypothetical, your answer, when again you answered it no, is that even in the face of seemingly contradictory or actually contradictory statements by the doctor prior to presenting the consent form, you would still need an expert to say, yes, you can't really square those. Those are truly contradictory.
Yes.
Okay.
I mean, I think it can be resolved on the consent form, but if you're trying to overcome the presumption with these oral statements, then, and not just his inability to read, then yes, you would need the expert testimony.
But aren't consent forms really used to supplement what the doctor said? I mean, the doctors go through this litany, but they don't cover everything. I mean, not every little thing that can go wrong. That's what the consent form does, and that's why you have to read it.
Correct.
I find it hard and maybe unfair for us to put a burden on the doctor to say every little thing that could possibly go wrong that the consent form has.
Yes, that's the reason you present that they are bound to that consent form. It does supplement and list anything that may have not been covered in an oral conversation, because usually the there's usually a long list that if you sit there and orally go through every time. And so the presumption in any contract, even outside of healthcare liability, is that if you're going to sign a document, you read it or take whatever other measures necessary to understand it. It could be that you don't understand what a term means and you have to ask the doctor, hey, what does this word mean? I don't understand.
We have misrepresentation in this context if the doctor's saying, this is the greatest procedure, never any problems, it goes fantastically well, I'm the best at this in the whole country, you're going to be just fine, when the list itself conveys something different in terms of what potentially could happen. Does that qualify as a misrepresentation that would overcome the presumption of the form essentially providing an adequate basis for informed consent?
No. I think back to Judge Bennett, if you make the doctor say orally everything that's in the consent form, there's no purpose in the consent
And if you
form.
say, hey, I'm the best in the field, you're in good hands. Okay, well, that's nice. It's nice to hear. But, that's kind of like having a salesman say this is the best car, in America, and you should buy it. And to say, I've had 100% success rate. Well, so far. But, that's talking past. Maybe there are implications for the future from the past, but, that's what the consent form is for.
And one thing that we've not touched on that's in our brief is this issue that plaintiff has raised that Dr. Herbert had a duty to disclose, and that created this inadequate disclosure, this misrepresentation. And in the briefing, we cited a Homestead Group versus Bank of Tennessee and PNC Multifamily Capital Institutional Fund versus Bluff City and Development Corporation. And those it talks about when there is no misrepresentation or inadequate disclosure, when ordinary diligence would have revealed the allegedly undisclosed fact. So in this case, had he read the consent form, all of those risks would have been lined up. He didn't in this case. He signed it. And under Tennessee law, well-established contract law, he's bound by that signature. It was plaintiff's responsibility to take whatever steps were necessary to read and understand the form before signing, or to sign and be bound by it was kind of the...
It's certainly not the typical circumstance where somebody is going to have an inability to read a document. How do we look at that in terms of the presumption and allocating burdens where you've got someone who does have a vision problem? Is it Vanderbilt that's responsible for, can you read this document? Is it the responsibility of the patient to say, hey, I've got a problem with reading the document, I need you to read it to me? And if so, isn't a responsibility that exists every time? I mean, is every time that Mr. Jarnagin comes into the hospital, every document he has to say that? And how do we allocate the burdens there?
So I think first, based on Tennessee law, again, and contract law, which I keep belaboring, it's, this person signing the document's burden to either read or take steps necessary to understand it. So based on that, it would fall on Mr. Jarnagin to do whatever is necessary to either read or to understand the document. In this case, I also note his wife was present, knew he had this vision problem that Vanderbilt kind of takes as true for purposes of this appeal. He could have asked her to read it to him or read it and explain it to him. He could have. I also note that this was signed on January 7th, 2019. The procedure was not until January 25th. He said, I'm going to take this home, get a magnifying glass or let my wife look it over or someone else look it over, and I'll bring it back later or call if I have any questions. It's not like he was being willed into the OR right then and had to sign it.
The statement that this just, and I'm roughly paraphrasing here, but the statement from Vanderbilt medical personnel that this just repeats what the doctor told you, was that made on the 7th, or was that statement made later?
It's unclear from the affidavit. So there's a lot of talk in both Mr. Jarnagin and his wife's affidavit about the January 25th consent form, which there is no consent form signed by him on January 25th. It's only January 7th. So even giving the benefit of the doubt that it's January 7th, it doesn't matter. That oral conversation, there's no proof in the record. Well, one, plaintiff actually didn't make that argument at the trial court level regarding this other person. But even outside of that, it doesn't matter. There's also no proof in the record that the assistant was in the room when Dr. Herbert allegedly gave these oral statements. So there's no proof that this assistant actually knew what was said versus just a casual, oh, this is maybe what the doctor had gone on earlier to be a fraudulent or intentional misrepresentation. But regardless of what the assistant said, the form was still in plaintiff's possession. It was still plaintiff's burden to read or take what other measures were necessary to understand the form before signing it. Whatever that made, having his wife read it, asking to take it home to get a magnifying glass or let someone else read it to him later, or somehow enlarge it, or ask if there was a larger copy available, or make that assistant sit down and actually read the form to him before signing it. It was his choice to sign it, and under Tennessee law, he is bound by that signature. Particularly in light of the fact that had he read it or someone or had his wife read it to him, that would have been, those risks would have been disclosed to him.
So he had the document for weeks before the procedure was performed, a copy of
No, I'm saying he could have asked, so can I take this document home to read it? He signed it on the same day. In my remaining time, I just want to kind of ask the court to think about and consider, if it accepts plaintiff's argument, the impact that this has on contract law in general. It opens a Pandora's box that not only in the healthcare liability context does it render consent forms meaningless, but it also has the broader impact on contracts generally. That if you don't read intentionally, you can later get out of it, or if you skip a section, you're not bound by that section. I will also note that plaintiff has not cited any cases that the inability to read or illiteracy gets you out from under a signed consent form to create that, to rebut that presumption of consent.
Thank you.
Thank you.
Mr. Thomas?
Thank you. I think I have the answers better prepared from earlier. With respect to comment of what was included in the affidavit, I do recall that the patient himself does not remember this form being placed in front of him. However, his wife said in her affidavit, I was present at the appointment in early January 2019. My husband could not read the document, which she referred to as the informed consent document. I do not recall this document was read out loud to him. I recall Dr. Hevert's assistant handing my husband a document and requesting that he execute the document. The assistant stated that the document discussed the information that Dr. Hevert disclosed to my husband as outlined above, which is 100% success rate, etc., with the one issue including the side effects of the injection site. As to the expert opinion, the expert considered the statements of the patient and his wife. In the expert report, it says that I not only looked at the medical records, but I also talked and considered the statements of the plaintiff when making his opinion, and found, without having seen the document, the informed consent to be improper. And if ultimately the informed consent is thrown out based off of this confidential relationship and or this misrepresentation and or the fraud by silence, the expert opinion still stands. There's no informed consent document that's been executed. Any other questions, Your Honors?
No.
Thank you for considering this interesting argument.
Thank you for coming all the way here to present it. Thank you both. I believe we're ready to adjourn for the morning.